Political impasse in Rivers State is not showing signs of abating as either sides of the divide continue to throw punches at each other. The latest is the judgment of the Court of Appeal in Abuja, which dismissed the order of the Rivers High Court that's restrained Martin Amaewhule and 24 others from parading themselves as lawmakers of the State House of Assembly. The three-member panel of the appellate court, led by Jimi Olukayode-Bada, held that the trial court lacked jurisdiction to entertain the suit. Such matters can only be heard and determined before a federal high court. So matters get the legal perspective of Olayinka Oladaniels, a lawyer. He joins us virtually. Good evening to you, Mr. Daniels. Thank you so much for joining us this evening.
Good evening. Thank you for having me.
Right. So now that the court has nullified the ruling which sacked Martin Amaewhule and 24 other members of the Assembly, what's next?
Well, there is no hassle with this. It's just that some people always try to, use anything as an opportunity for their mischievous way of handling things. The court is clear about what he has said. The Court of Appeal is clear. And when I heard some people saying, anyway, I think the person that was saying that is the imposed speaker of the House of Assembly, because you cannot say Court of Appeal court has heard. It is clear, Section 272, subsection 3, made it clear. And we all know that this particular matter, it is exclusive to the Federal High Court. And if you are going to State High Court to seek such order to declare a seat vacant, a seat of the member of the Assembly vacant, I think you should be the one that I've heard here, because the High Court does not have jurisdiction to adjudicate over that matter. It is a Federal High Court matter, exclusively for Federal High Court. And that is what Court of Appeal has said. In the first instance, Mr. Speaker, the imposed Mr. Speaker has no right to even declare a seat vacant. There are processes that must be followed for a seat to be declared vacant. And it is not in the power of, because section 109, subsection of the Constitution if for any it's sponsored by a political party, and the member has decided to leave that political party to another political party before the end of the terms of the Assembly. And how do we decide that? How do we determine such thing? The provision of that section that can only be determined by the court. It is when evidence is and strikes, there are issues, there are chaos, and all that in the political party that brought them into to the Assembly, and they can say, oh, because of this, there is no peace among the political party members. So we cannot stay any longer in this party. We need to move. If they can defend that, if they have enough evidence to prove in court that, yes, they have been able to, to prove that in court, yes, the court will look into it and decide. And if the court is not convinced by evidence, by whatever they bring to court, and court is saying, no, you cannot jump from one party to the other party because this is your excuse, this is your reason. The court can say,
all right, Mr. Daniels.
Judgment of the court. Yes.
Mr. Ola Daniels, do you think, what you're saying now is that perhaps we need a higher court to determine or interpret what constitutes division in a political party? Is that it?
Take that again.
Are you indirectly saying at this point we may need a higher court to interpret or determine what constitutes division in a political party?
No, you see, see the issue right now. Even the court that would determine what causes the issue in a political party is not the High Court. These people went to the High Court. The AU went to not determine, because the High Court does not. The High Court of Rivers State does not have jurisdiction.
All right.
It matter.
All right. Looks like that's the key point. It looks like that's the key issue,
yes.
Jurisdiction. Now, what is the implication of this judgment for politics in Rivers State?
Well, the implication of this judgment is clear. Is to say, look, whatever the decision of the High Court, whatever the order of the High Court of Rivers State is void and void ab initio, is illegal and not ab initio. The implication of judgment of court property is taken. Of the four members vacant. You cannot. So meaning that these people are still a member of the State Assembly of Rivers State. Their seats cannot be declared vacant. Now, whether they have decamped to another party or not is another issue entirely, which they still need to go back to the right court. The court that has jurisdiction to hear this matter. But as we speak, and from the judgment of appeal, because the court that given that the order is illegal, the order is void, ab initio. The court does not have jurisdiction to decide on this matter, so it cannot give a judgment on the matter. So as it is, if anybody has to go to court for any redress, they have if they want to declare this seat vacant, the 24 lawmakers seat vacant, then they have to go to Federal High Court, which is the court that has jurisdiction to decide this matter.
So is the Federal High Court now the arbiter? Because I mean the other parties have said they are going to the Supreme Court.
It is a constitutional matter, and that is section 272 subsection 3 of the Constitution. The question is, who has jurisdiction to hear this matter? Because when they are going to Supreme Court, they are telling Supreme Court, look, Court of Appeal has voided the order of the lower court, which is the High Court of Rivers State. You are going to Supreme Court to say that. Then Supreme Court will look at the judgment of the Court of Appeal and look, okay, what is the judgment? What is the prayer? What is this sort in this matter? So this thing is not ambiguous in any way. And don't forget that the court is not a Father Christmas. It is what you take to court, the court will give you. So if they are going to call the Supreme Court, they are free to go to Supreme Court on this same matter. But I can tell you that the Supreme Court will align with the judgment of the Court of Appeal.
So if you say this order is not ambiguous, why are lawyers divided on whether or not Section 1091G is self-executory?
No. You see, it's set again to, don't forget that some people are mischievous and so that they give different interpretations. I mean, the bar and the bench. That is the reason why we have the bench to decide, to determine, and to look critically at lawyers bringing to the table. Now, if some lawyers are saying Section 109G is explanatory, don't forget that. Don't forget that this same Constitution gives freedom of speech and gives so many, sections of law to the citizens. But for instance, when we talk about freedom of speech, don't forget that this same law made it clear that your freedom of speech stops at yet another. Your freedom of speech and whatever you do stop at where another one starts from. So the Constitution, yes, may say something. The sections of the Constitution may say some things. I'm not. For instance, when G made it clear to say, okay, that the seat to be declared vacant, nobody. Don't forget that all the members of the House of Assembly are representing different constituencies. They represented people. So, irrespective of the fact that they came into a political party, they need to answer to their people. So if their people had not said, no, these are not the people we are sending. So you cannot. The only place you can seek redress is to go to the judiciary. That is why we... say, oh, the seat will be declared vacant. Don't forget, if you look down, even to subsection 3, to 2 and subsection 3 of section 109, it's explained.
Salah Daniels, are you there?
Yes, I can hear you. I'm here. I'm still here.
So I hear everything you've said, but some rep members have also reacted to this matter, and one of them, Honorable Kenga Gochinyere, has said that Martin Amaewhule and the other 24 members of the Assembly remain sacked. I mean, he said the Court of Appeal only ruled on the jurisdiction of the Rivers State High Court to hear the matter and not the main substance of the matter. Could you clarify this?
Thank you. When you say not the substance of the matter, what is the substance of the matter? Can you, if there is no public stand? Now, when you talked about the substance of the matter, what is the substance of the matter? That the Speaker declare the 24 members seats vacant. Does he have power to do so? The answer is absolutely no. By the provision of section 109, subsection 1G. It does not have absolute power to declare seats vacant. Now, who went to court, to the High Court of Rivers State? This same set of people went to the High Court of Rivers State to tell the court to declare the seat. Why did they go to the court of, to the Rivers State Court? If they think is what if the speaker think is what the imposed speaker think that he has the power to do so. Why did they proceed to the High Court to still get an order to support his own invalid action that he has made? That is the substance. Now, Court of Appeal has said that where the foundation that you're claiming you have is faulty. And that is the Rivers State High Court. You cannot go to Rivers State High Court because Rivers State High Court does not have jurisdiction. They know that they don't have, the speaker, the imposed speaker knows that it does not have power. It does not have power to sack or to declare any seat vacant. That is why he tried to look for the backing of the court to support his illegal action. Now, he made an error by going to High Court, which does not have jurisdiction to preside over such, to adjudicate over such matter. Now, Court of Appeal had made it clear and said, look, your foundation is faulty. We are not for that Christmas. This what you are looking for, we cannot give you. So now, because you do not have jurisdiction, whatever was the decision or was the order of the court of the Rivers State High Court is null and void. Which means these 24 people remain lawmaker of River State.
All right.
Because the imposed speaker does not even have jurisdiction to declare their seat vacant.
All right.
Now, the order they obtain to declare it vacant is null and void, is illegal.
I mean, I get that, Mr. Daniels, but I mean, the next question would be, why do judges entertain cases they do not have jurisdiction over? Isn't this an indictment on the judiciary?
Thank you for these questions. And this is where some of us we have made noise, we have talked, we have cried, because this is simple. And we have said that we need serious reform in the judiciary. We can see that how politicians they try to mess up the judiciary, pollute it by all means because of their own selfish ambitions. We can see how one person will go to a court of this coordinate jurisdiction for the same matter in 10 different courts of same coordinate jurisdiction, getting different orders from this court. These are the things we are talking about. There's no reason why this Rivers State High Court should entertain this matter, because this matter, it knows that it does not have jurisdiction over this matter. There is no reason. Some of us will plead with the Chief Judge of Nigeria to call these people to order. This particular court needs to be addressed. And I think the NJC should do something about it. If you know you do not have jurisdiction, we don't have to go all this hula baloo. We don't have to be doing this all the time. And we know what is wrong. We just want to make fool of ourselves, of the profession. We don't have to go this route. You know that you do not have jurisdiction over this matter. Tell them to go to the appropriate court for redress. Rather than embarrassing the judiciary with your selfish reasons. We have cried enough. This is not good for judiciary. How will a common man feel if all these political gladiators are doing this?
So, Mr. Ladanes, if eventually a judicial reform happens, what kind of penalty or punishment suits this unprofessionalism?
For me, I will leave that to the agency to decide really on the penalty that should be melted to this kind of a thing. But for me, it's a no-no. We are not encouraging it. We are saying no to it. We need a strong and formidable judiciary, and this cannot be part of it. This is really messing up our democracy. We want a strong democracy, and if one of the pillars of democracy is the judiciary, then we should avoid shaking the pillars so that the house will not crumble.
All right, great.
So I will leave the decision of punishment to the agency to decide.
All right, thank you so much. That's where we leave this conversation tonight. Thank you so much for joining us tonight. Mr. Olayinka Oladanios is a lawyer and also a political affairs analyst. Thank you so much for your legal perspective to this matter. Thank you, and I look forward to more conversations with you. Thank you so much. Have a great weekend.